to see if the developer would like to be here for any rebuttal, but they are no longer here. We're not sure where they went. So we'll move forward to a summation by the appellant.
Thank you, members of the board. I appreciate your patience through this long process. I want to draw your attention back to our original appeal of this matter and the three things that were mentioned earlier that were our complaint. The first one, and perhaps the most important one, being that the Planning Commission process did not allow for public input in a manner in which it should have allowed for public input. And, specifically part of that complaint was that the Planning Commission was misled by the comments of the county attorney, deputy county attorney. I think that particular issue is less concerning than the fact that the public was not allowed to comment. The Planning Commission was, because of that, denied important information that we have brought to light in front of the Board of Appeals. And specifically, I want to indicate to you some of the conflicts as well that we addressed, and that is that Article 5 of the Planning Commission's own rules indicate that the public may address the commission when called upon by the chairman. That was not exactly brought to light during the Planning Commission procedure and was stated in a perhaps misleading way to the commission. In addition to that, and more important than that, the county's own subdivision regulation, Section 25I, makes testimony by the public obligatory, stating that the commission will review the application, public testimony, the report of the planning director, as well as any review agency comments, and then act for approval with conditions, deferral, or disapproval. Obviously, the Planning Commission acted for approval of this matter without considering public testimony in direct contravention of that ordinance. Now, the applicant for the minor subdivision, for the preliminary subdivision plan, complained at the previous hearing that the project had been worked on for 6 years. What I want to draw to your attention is during that 6 years, not one of these people had any idea of what was going on and what was proposed in that subdivision plan. What I can deduce from talking to them is they had about 2 weeks' notice by reading board docs that anything was up at all with the Guilford project, and their only opportunity to have any input during that 2-week period was to testify at that Planning Commission proceeding. They were denied that. The comments also about making their input through staff can be also seen through the light of what Mr. Hastings had to say. I will tell you that having been around this county for many years, prior to the new administration, the new, as of 2006 administration coming in, or 2007 administration coming in the county commissioners, anyone in this county, to my knowledge, could have walked into the Office of Planning and asked to see I want to see every subdivision plat up and down Billingsley Road. And they would have brought you into a room and they would have laid them out in front of you to see. My understanding from people today, I haven't done it myself, but my understanding from people today is if you did that, they would say, here's your forms to fill out for your Public Information Act requests, which would have been handled in the same fashion that Mr. Hastings' requests were handled. I can tell you that myself from my own experience in filing Public Information Act requests with the county, that I have never had granted within the 30-day period, and the ones that I have had granted, many of them have been extraordinarily problematic to the point of bringing lawsuits over them. That is to bring to your attention how unacceptable it would be to say that these people have adequate input through staff. It is not necessarily staff's problem. I'm not saying that, but the policies of the county having to do with public information are obscene, and it should be handled in an entirely different fashion. If it were, they might have some adequate input through staff. But it also begs the question to say that they would have any adequate input through staff, perhaps, because staff's not who makes the decisions. These people have the right to address the decision makers and not to someone else who is, in essence, a witness also to testify in front of the decision makers. And that's what the staff become, because the buck stops with the Planning Commission and with you. That is where it is supposed to be. And it does so in an extraordinary fashion, because, as you know, there are appeals beyond you to the circuit court. And in those appeals to the circuit court, those judges are very careful not to divest you of your authority to make policy decisions. They will not make those policy decisions up above. They will make decisions having to do with process and law. But they are not going to make those policy decisions. You are, and the Planning Commission is. That's what, in fact, the Army Corps of Engineers emphasized that in a striking way that maybe you have to stand back and think about for a minute. And in our Exhibit 5, they did just that. Exhibit 5 being essentially communication back and forth between Mr. Beal and the Army Corps of Engineers having to do with the cross-county connector. And the comment that my clients have pulled out of that document reads that this is the Army Corps of Engineers speaking to Mr. Beal, indicating the county cannot rely on state and federal regulatory programs within their limited scope of review to protect the aquatic resources of Mattawoman Creek. So who does that? Who does that? The county commissioners may do it through legislation, but in terms of looking at individual projects and deciding those things, who does that? You do. And the Planning Commission does. And when they do, they have to be provided with adequate information. And probably just as importantly, these people have to be provided an adequate opportunity to present their side of the picture, whether or not they have a side to present.